Yes, yes.
The Trust College of MCA, Vidyabharati Cooperatives Credit Society, NABL accredited Civil Material Testing and Environmental Audit Cell. Along with this, Om Bhojanalay and Texas Multispeciality Hospital is a part of Vidyabharati Trust. Moving ahead to SN Patel Institute of Technology and Research Center, that is SNPIT and RC Umrak, is established in the year 2008. I proudly say that it is first technical undergraduate institute in Bardoli region. SNPIT-RC is approved by AICTE and affiliated with GTU. We are offering undergraduate courses in following branches: electrical engineering, mechanical engineering, civil engineering, chemical engineering, computer science and engineering, and IT engineering. We are also offering postgraduate courses in construction engineering and management and production engineering. In this academic journey, Institute has done the excellent work in achieving academic goals. As a result of students have received gold medals from GTU. Our qualified team members of SNPIT-RC with more than 25 faculty members are either completed PhD or pursuing PhD from reputed institutes like IITs and NITs. So it is requested to all to visit once and have insight of Vidyabharati campus. Thank you.
Thank you, ma'am, for your kind presence and support. Okay, so before we start, uh, let me give some introduction about this session. This is the today we have two lecture sessions, and these lecture sessions are sponsored by Ministry of Education, Council, MIC, Government of India, and AICT. These lecture sessions are meant for creating awareness and creating awareness among students and faculties about entrepreneur, innovation, and intellectual property rights. The Impact Lecture series will be also beneficial to young new innovators and entrepreneurs in removing the bottlenecks in their ventures and earn revenue by patenting their innovations. IPR can enhance your business market value. It helps to raise finance. It can help you to stand out from competition. In general, IPR awareness in students is conducive to fostering creativity and innovation in the country. More about the IPR, we'll listen from our speaker, ma'am, in few moments. Now, I will introduce our chief speaker today for the impact lecture session on the subject of intellectual property rights and patent search. Uh, our speaker is Mrs. Preeti B. Chothani. She is a registered Indian patent agent. She is also the co-founder and CEO of Sri Datta Law Consultancy, Gandhinagar. She has successfully completed a number of IPR related courses and has received awards like Young Entrepreneur Award, GIC I2I award by GTU. So I am not taking much time. So I will hand over the mic to our ma'am, Mrs. Preeti B. Chauthani, to start her lecture about the topic. Ma'am, please.
Yeah, thank you so much, sir. Very good morning to all. Without wasting a time, I am just sharing my screen and we will start our today's session. Is my screen is visible?
Make it full screen.
हो गया हो गया
Okay. So, sir, may I speak in only in English or I can give the session in the bilingual language?
Ma'am, you can continue because as the students are very, that means they can understand, but to make it more, what you can say, more understandable and non, too much formalities words in between also in Gujarati or Hindi. The students will be more comfortable. I think so.
Okay, so as thank you so much, sir, and the ma'am for providing me this opportunity. And so I'm taking the session on the fundamentals of the IPRs and the patent search. So basically, we will learn about the what are the IPRs and what are the different types of the IPR. So the basics about the IPR as well as how we can, if you have any of the idea in your mind and if you want to protect it by the way of the IP, either it's a patent, trademark, design, any type of the IP. So how you can do the search for that, and from that you will come to know that whether your invention or your idea will be protected by the IP or not. So that search also we will learn in this session. So this is just the formal disclaimer that this presentation is only for the educational purpose only. We are not infringing anybody's intellectual property, and I have prepared this presentation based on my experience and the knowledges. And I have taken some of the images from the Google for the educational purpose and to give the more clarity to the students. This is the flow of the presentation. Basics about the IP means the intellectual property and the IPR, intellectual property rights. Then which are the different types of the IPR. In that we will learn in detail about the copyrights, trademark, industrial designs, patents, patentability search. And in last we will go through all the different types of the searches used for the different type of the IPRs. That is IPR search and the question answer session. So basically what do you mean by the IP? So IP is the intellectual property. We can correlate it with the innovate to impact, mind to market, or research to revenue. So if you have something in your mind and from that if you can generate your revenue or the money out of those things, then for that intellectual property plays a very important role. So if you have come up with any idea, if you have written some poem, if you have written some songs or the lyrics of the songs, then if you have come up with any new research technology, and for that perspective if you are applying the IP on that, IPR on that, then only you can generate the revenue out of that. So basically if we are taking the idea about the properties, what is the property? So two types of the properties are there. One is the tangible property, another is an intangible property. Now tangible property means what it is in the physical form, which can be touched or felt. Means everyone knows that this jewelries, land, automobiles, furniture, all are the property types, right? But they are tangible. If someone is telling that I have a car, so you can touch that car and you can feel that you have a car. If you told that I have a house, so you can touch those things and you can feel those things, okay, this is my property because this is on my name. So all these are the tangible properties, and another is the intangible property, means the creation of the mind which cannot be touched or the felt, like any ideas, any creation. If someone is come to you and told that I have come up with some new poem, I have written one new poem, so you cannot touch those things, but you can see those are the intangible properties which are comes from our mind, and that may be any of the creation, any of the research work, any of the ideas in that. So basically the intellectual property is an intangible property which includes the creation, of the human intellect or the human mind. So anything which comes from our mind, those all are comes under the intangible property, and that is also known as the intellectual property. Is this clear? What is the intellectual property?
Ma'am, if you are asking, because I cannot take any answer from the students,
Okay.
it is, you can carry on.
Okay. Or maybe if possible, people can write in the chat box also. So thus, I can
Okay.
move forward whether they are this clear with this concept or not.
Okay. The students and the participants are requested. If you have got any question, you can write in the chat box. So we can pass on the questions to the our speaker, ma'am. So he can answer it. If any questions will come, we will share with you. Right now, you can continue,
Okay, sure, sir. Thank you.
ma'am. Okay.
So now we come towards the intellectual property rights, right? So the intellectual property concept will be clear now. And any rights which are given for this intellectual property, those are known as the intellectual property rights. So the intellectual property right is basically, if we define these things, it provides the protection over the intellectual property, and this IPR, intellectual property rights, are the rights given to the person over the creation of their mind, and these rights are the exclusive rights given for the certain specific period of the time. So if we are breaking this definition, what exactly the intellectual property rights? So in the layman language, anything which gives the rights for the intellectual property, those are the intellectual property rights. And these are given for the creation of the mind, because intellectual property is the intangible property, and it's given that properties comes from our mind only. So for that creations, for those ideas, research, or anything for that which are comes from our mind, for that this rights has been given. Then these are the exclusive rights, means it stops others. If you have a patent for some particular product, and that patent has been granting you rights for that particular product patent, then you are stopping others, means it's the exclusive rights, means it's exclude others. So you are stopping others from manufacturing, from selling, from exporting, importing your product. So based on that exclusive rights is what is given. All the IPRs, either is patent, trademark, copyright, anything is there in the types of the IPRs, all are the exclusive rights, means you are enjoying your monopoly, with that you are stopping others, and it is given for the certain specific period of the time. So different type of the IPR having a specific time limit, for that specific period that rights has been given, that is not given for the lifetime. So in very general sense, if we are telling that the IPR is in that the IP will be remains in the secure hand. So if you want to protect your ideas or your invention, then you have to apply for the IPR, and then and only your idea will be remains into the secure hand. Now different types of the IPR. So most widely used are the patents, industrial designs, trademark, and the copyright. And other than that, the trade secrets, geographical indications, semiconductor integrated circuit layout design, then plant varieties, and the breeder's right. So for this patent, designs, trademark, and copyrights, we will learn in detail in the upcoming slides. Other than that, the other four types of the IPR. So trade secrets. So best example for the trade secret is the Coca-Cola. So the composition or the ingredient which are used in the preparation of the Coca-Cola and the process for that making of the Coca-Cola, both are protected by the way of the trade secrets. So no one knows about this Coca-Cola related composition and the process. In the other types like patents, trademark, design, copyright, so things will be published on the portal of the Indian Patent Register or the Indian Patent Office. So all people will come to know, okay, this type of technology is protected by the way of the patent. Now people will come up with some advancement in that, and they are again filing the patent, or they are surviving into the market. But in the trade secret, no one knows. Only that companies, 1 or 2 person will be there, those having a idea about the composition and the process about the these things. So that's why it is known as a secret. So it's a trade secret. That for that the best example is the Coca-Cola. Then second one is the geographical indication. So that is related to the specific geographical region or then specific region. Let's for example, we all know that the mangoes are famous from the Gir Kesar region. Then the tea is famous from the Darjeeling region. So particular region having a particular climate condition, particular land condition, and the quality, based on that, that particular product will be planted from that area, or will be grow from that area, and it give the best quality because of the climate condition of that particular region. So if you are propagating the mangoes in your region, that may be not that much having a good quality as compared to the Gir region. Sorry. So for that particular region, region wise, this type of the IPR is given, that is the geographical indication. Then next one is the semiconductor integrated circuit layout design. So any of the electronic and communication related department or the electrical department, from that they are come up with any new chip or new circuit having a new design in that, right? So for that the patent will be not applied, but for that separate protection will be given, that is the semiconductor conductor integrated circuit layout designs. Then any of the new plant varieties will be come out having a merger of the two plants, they're combining the two plants and giving the some new plant having a better quality. So for that, any type of the plant related inventions are there, ideas are there, some new thing will be there that can be protected by the way of the plant varieties and the breeders' right. Then now we will see the most widely used IPRs are the patent, design, trademark, and the copyright in the pictorial presentation. So
Hello.
yes.
Ma'am.
Yes,
Hello.
sir. Yes, sir.
Hello.
Yes, sir.
Sometimes your voice is breaking. I think net in your side.
Okay.
Uh, now it is. Should you stop your video? I think it will make the audio clear.
From my side also, I will try to stop the video. So maybe.
Okay. 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 Now it is audible. You can carry on.
Okay. Okay. So this is the basic pictorial presentation for the most widely used the IPR. So any of the logo or the word or the sign that can be protected by the way of the trademark. So if you all know this is the branded product, this is the branded things. So those branded means they having generated the brand by the way of the trademark. They have protected their name, they have protected their logo by the way of the trademark, and that's why they're creating the brand
Excuse
into
me,
the
ma'am.
market. Yes, sir.
Hello, ma'am.
Yes, sir.
So, ma'am, what is the meaning of intellectual?
Intellectual means it comes from our mind.
It comes.
From our mind, any idea which comes from our mind. So if you are a student in the engineering field, you are come up with any new technology related ideas, or you have come up with some new instrument, you have prepared those things, so that comes from your mind. So that anything, the ideas which are comes from your mind, that can be protected by the way of this IP.
Oh,
Okay. So as I told, that any of the brand name or the logo that can be protected by the way of the trademark. Then in the patent, so any of the scientific inventions or the any technological advancement will be there. If you have come up with any new instrument, any pharmaceutical industries, they have come up with any new medicines, new formulation of the already known medicines, all those things are the inventions, scientifically inventions, so that can be protected by the way of the patents. Then any articles with the unique design, that can be protected by the way of the design. So any of the pen will be there, the all pens having the different design structure will be there, right? So those all things.
Ma'am.
Yes.
Ma'am, your screen is not visible. Are you sharing anything? It is
No,
not
I
visible.
am sticking on that pictorial.
No, that picture is also not coming.
Okay, so let me share again. Just a minute. Is it visible now?
Yes, ma'am. It has come. It has come.
Okay, okay. So if we are taking the very normal example is that the pen. So each and every pen having a different design over there. So those things, the things, basic thing is the common, means all the pens are used for the writing purpose only, but their design perspective, their aesthetic perspective, their look, as per we are concerned about the look, so they are having a different unique look over there. So those all the things can be protected by the way of the designs. Then copyright, to any literary work, any poem or the songs written written, then any musical things are there, dramatical artistic work, these all can be protected by the way of the copyrights. So these are the different types of the IPR and the IP. IPR and the definition about the IP. What is the IPR? So is it clear till this?
Excuse me, ma'am. What is the important role of IPR in chemical industry, chemical engineering? Sorry.
So in that also, if you are come up with any new process which is already not known, right, or you are come up with any new product for that, let's for example any you are using some chemical wastage to prepare something new product for that. Let's for example any brick is there, right? So that brick will be prepared from any chemical waste. So that is the not a new thing, that is not the common thing, because you are using some waste of the chemical industry and you are utilizing those waste for the some beneficial things. So that is the new thing, or that is the new advancement in the technology, so that can be protected. Or you are come up with any.
Ma'am,
Yes sir.
are you there?
Yes, yes.
Hello?
Yes sir.
Hello?
Yes sir. Am I audible?
उनका आवाज बंद हो गया. Hello? Is that?
Yes, yes, I am here only sir.
Oh, no, ma'am. Unmute your mic. You are not audible.
Okay, sorry. It may be.
Yes. It.
Yes,
Now
yes.
you can audible. Now,
Yes,
now
yes,
you are
sorry.
audible.
Sorry. So, Akash, I'm telling that if you are come up with if you are using any of the this is just an example. If you are using the any chemical waste for preparation of the any productive things, like any of the brick that will be prepared from the chemical waste, so that is not the known thing, right? You are come up with some new ideas and you are preparing those utilizing those waste for the creation of the some useful product out of that, or you are come up with any new processes for preparation of the some particular chemicals or the some particular product that is not known before. So all those kind of the things you can protect by the way of the IP in the field of the chemical engineering or the chemical field.
Okay, ma'am. Okay.
Okay. You will get a more clear idea once we will finish this session, because in that for the patent perspective we will go in the depth, more in depth.
Okay, ma'am. Definitely.
Yeah. Okay then. We are moving over. Yes. So first we will see the what is the copyright. So copyright is also, as I have told, that all the IPRs are the exclusive rights, means they are using if you have any rights of the IPR, you are enjoy your monopoly in the market as well as you are stopping others. So you are excluding others. So copyright also exclusive rights given by the law of the certain terms for the years to the author or the composer or his assignee to print, publish or sell the copies of his original work. So if someone is come up with any new poem, so they are or the bhajan or the song lyrics, so they will apply for the copyright, and that will be remains for the 60 years after the death of the author, or someone is come up with any movie or like that. So for that also they are applying the copyrights. For any of the websites we are seeing in that, in the lower part, if you will see that they have write down that this is the copyrighted as per this year or like that. So all these things can be protected by the way of the copyrights, and for that term will be the 60 years after the death of the particular author or the composer. Then what can be protected by the way of the copyright? So it's a literally or dramatic work, musical work, artistic work, any cinematography, film will there, any computer generated work, because in India any of the softwares cannot be patented, so that can be protected by the way of the copyright. So these are few examples are there. If we can see that these are the some website will be there, in that they have write down the copyright under the 2020. Then these are the any literally work if you
Ma'am,
write down something.
voice is breaking sometimes. Okay.
Don't know.
मैम चालू रखिए.
Okay. Or some artistic work will be there, recording will be there. So all those things can be protected by the way of the copyright. In Twitter also, if we can see that they have write down the C means is the symbol for the copyright, and it is copyrighted as per the 2021. So all these few examples are there for which the copyright has been applied. Is this clear about the copyright?
Ma'am. Ma'am, at the end we'll have the question session.
Okay.
We are not allowing any students in between.
Okay, no worries. So, have any question, they can write in chat box or they can remember those things.
Sure, ma'am.
Okay. Then coming to the next type of the IPR, that is the branding and the copyright. So, trademark is a sign distinguishing the goods or the services produced or the sold by the one enterprise from the those other enterprise. So if some particular things we selling the some particular product, let's for example any of the soft drinks will be there, so that soft drinks will be selling by the Maja also, by Coca-Cola also, by Thumbs Up also, and by any other brands also, right? So why you are preferring some particular brand only? So because it's distinguishing that this is of this brand and having this type of the quality, and that's why you are preferring those particular soft drink only. So if you want to distinguish the two goods, both are the from the soft drink company only, they are selling the same cocoa. If we are telling the Thumbs Up and the Coca-Cola, both are in the same in the look, both are maybe little bit difference in the taste also. So if you distinguish these both the goods, then for that the trademark is very useful. For the services also, if any type of the service is provided by the two different companies, so if they have applied for the trademark and the trademark will be registered, then it will give the more impact to the client also, that they have applied for the trademark, and this is may give the very good service as compared to the other person or the other company. So it like a brand name, and we can say that it is the kind of the visit card that promotes the image of the company and its range of the goods and the services. So if we are want to buy any of the, let's for example footwear, so why you are preferring the Nike or the Puma or like that, right? Because they have already created that brand, and that brand will be created by the way of this trademark only, and it's now it's act as a visiting card for that particular companies. So for the term for this trademark is it remains valid for the 10 years, and that can be renewed for the unlimited times of the 10 years period. So first 10 years that will be valid, then if you want to renew, then you have to pay some fees for that, and next 10 years it will be there. After that also you can renew it until the unlimited time for that. Then the different types of the trademark also. The one is the trademark, then service mark, collection mark, certification marks. So the trademark means it's distinguishing the goods, right? Any of the product will be that can be distinguished by the way of the trademark. Any of the services that can be distinguished by the way of the services. Then if you are combining the both collectively, it's goods as well as the services, or any member of association. So any university will be there, or any colleges institute will be there. If they having a particular logo will be there, so they can apply in the form of the collective marks. Then certification marks like the ISO certificate, ISI certificates, so for that also can be protected. Why we are picking some of the product which are having a low ISO certificate or the ISI certificates, because they have giving this surety that they have providing you the good quality products, and for that they have also applied or taken some of the IP rights on that. So if you can from the now onwards, whenever you are purchasing some goods or whenever you are using any of the goods, so you can just see that whether they have written on their name R or the TM. So TM means unregistered trademark, they have just applied for the trademark, but trademark will be not registered. And if you will see the R over there, then that means that trademark will be registered now. So these are few the examples are there which related to the trademark. So here if we are say checking that in the McDonald's they have written the R means that the trademark will be registered, and in the Starbucks they have written the word is the TM means they have applied for the trademark, but still that process will be ongoing. Then word mark means you are write down the Starbucks, device mark, this all are the trademark only. This is different types of that. So if the device mark means it's a logo over that which having a name or they don't have a name about that. Then the Nike, so they have written R over there, that can be protected. Adidas will be there, Nestle, then Cadbury, Apple, LG, Samsung. So each and every brand having created their brand image into the market, they all have applied for the trademark. And that's why if they have applied for the trademark, as trademark is also exclusive rights, they are stopping others from using their trademarks. So if any phone company will be come and they are using they are just changing over here, they are changing in the spelling over there, and they are using the Samsung word. So the Samsung company can file a legal suits against that other company which you are using their name, because they have applied for the trademark and they have a rights to stop others. Okay, hope this will be clear to all. Yes. Now coming to the industrial designs. So in that these are the few examples which you can, so they all having a different shape, structure, different look in that. So this is also exclusive rights for the features of the shape, configuration, pattern or the ornament or composition of the lines or colors and combination thereof applied to any article in the 2 dimension or the 3 dimension. So if you can see, this is the chair, the stool will be there, right? This is also one type of the chair. These both are the chair are there. This is also a chair. This is also a chair. So both having a different structure, having a different color combination, having a different aesthetic look or the by the way of the looking towards these images. So it's both are the showing different. So if anything which you are come up with any new design or in that, so that can be protected by the way of the industrial designs. So if any new instrument is already available into the market, but you cannot come up with any new instrument, but you have just changed the design of that, and that can be protected by the way of the industrial designs. That is for the 10 years, and that can be renewed for the next 5 years after this 10 years. That must be a new, original and individual character that may be in the 2D or the 3D form. It will be applied to the wallpapers, textiles, furniture, toys, cars, phones. So if you can see any of the phone, they having a different design. In the camera also they have put the camera in the different angles, and based on that the design will be changed, because one phone company has prepared some smartphone having this type of the design, having 3 cameras in the line format, right, in the horizontal line. So another company will come up with these 2 cameras by putting in the longitudinal way or the landscape way, and by that they are changing the design. Otherwise, if that particular phone company have already applied for the design, then they also take a legal suit against the other companies. So in the spoon also, if you can see in the design, so they're having a different types of the spoons are there in the size, in the shape, or like that. In the lamp also there is a different types of that, then in the specs also, in the bicycle also, in the kitli also. So this is just a few examples. If you can see that each and every products having some unique designs, and that the companies will protect those design perspective by the way of the industrial designs. Now this is the design search for that. In that, this is the Indian patent search system will be there if you want to search in the Indian territory only. So in that, if you can write down the Indian patent office, then you can select this e-gateway, and by that you can search any of the IPR from that. So let's, for example, if you are searching for the design search, so in that they have given the multiple field over here. You can use the any application number if you have any persons who has already applied the design application, it's registered. Then if you have a number of that, you can add over here. Then date of filing, applicant name, then name of article means the title, that is the chair they have given, or rotating chair they have given, so that you can write over here and conduct the search. You will get the results of that, and based on that you can decide whether your design is eligible to apply for the industrial design or not, or if you are in the very initial stage and if you want to know whether in which direction you have to go to search the design. So for that also this will be helpful. If you have some idea but you can search in that, okay, this type of design is already registered, so you can modify those design, and based on that you can also then you can apply for the design registration. Then coming to the patent. So patent is a comparatively a strong rights, and patent is the exclusive rights given by the government to the inventor or the researchers to exclude others from making, selling, using, importing or offering for sale your invention for specific period of time, and that period will be the 20 years from the first filing date of patent application. Then and now the things come into mind that each and every research work that can be patentable, so that cannot be patentable, because there are few criteria are there. First you can check those criteria, and if your research work or if your advanced technology will fulfill those criteria, then and then only your invention will be eligible for the patent filing. So those criteria are known as the patentability criteria. So in that the three criteria are there. One is the novelty, another is the non-obviousness, and third one is the industrial applicability. Now novelty means a newness, new invention. If you are come up with any of the technology or the invention or the any research work that cannot be known in anyhow, either is not, it cannot be disclosed in any of the publication, either is a research publication or the review publication in India or in the world, anywhere elsewhere in the world, or it will be not disclosed into any of the books, it cannot be used into the market or for the trial purpose. So anything which the idea will be a new from your side that cannot be disclosed in anywhere in the India as well as in the world. So if those criteria will be fulfilled, the things will be a newer, then the novelty criteria will be fulfilled. Then coming to the another criteria, that is the non-obviousness or the inventiveness. So if your idea will be a new one, now you have to check whether it's a patentable or not. For that you have to check the non-obviousness. So in the non-obviousness, two things are there. One is the technical advancement and another is the economical significance. So if you have come up with any, आप लोग कोई भी एक इंस्ट्रूमेंट लेके आए हो या तो आप कोई भी फार्मास्यूटिकल प्रोडक्ट लेके आए हो, लेकिन आपको पता है कि उस ये जो पर्टिकुलर इंस्ट्रूमेंट है वो ऑलरेडी वो नॉन नहीं है, राइट, बट उसमें कुछ एडवांसमेंट भी होना चाहिए. इफ इट इज द एडवांस्ड in the way of the technicality, so वो advancement होगा, उसके साथ साथ it gives the significance. So if you are come up with any new type of the fan, we can say ceiling fan, but it in that some technical advancement is like that it will consume the less electricity, or it will give the some renewable energy to you, right? So for that it give the economical significance because it's consuming the less electricity. So for the non-obviousness perspective, your invention, your research work will be technically advanced as well as it's giving the some economical significance to the people in the society. Another thing is that for the non-obviousness things, if you have one article just showing that some of the part of your invention or the research, you have another article or the patent which having the another part of your invention, and if you are combining this both the article and your invention will be easily prepared, so that is not allowed. So if some person is from chemical engineering field, another person is also from chemical engineering field, and if that first person is come up with some new ideas and telling that my idea is the new and it's a patent, it's eligible for the patent, having a patentability criteria. So for that they have read that first person has applied for the patent and they have written that this type of the things are that which are unique in my invention, and that another person which is also from the chemical engineering field only. So if that person can read those patent specification, and based on that if the person can perform the trials in the lab, and easily if that person will come up with that invention which for which the patent has been applied, then that is not allowed for the patent. So that another person have to put some extra efforts in that to take some trials and errors over there, and based on that then after the trials and errors that person will be reached to the invention which are taught by the first person. So if the trials and errors are required, if the more experimentation will be required, then the non-obviousness things will be justified. And third one is the industrial applicability or the usefulness, means that any of the invention or the research work that can be easily made into the industry, and it will be useful for the industry as well as the society. So now in the patent search, how we will search for the patent, whether it is having a novelty, whether it having a non-based means is the patentable or not. For that we have to search the for the patent search, whether your idea will be disclosed anywhere in the world or not. For that you have to perform the patent search, and based on that you will get the idea whether your invention is a novel or not. So for that, patent search means finding a patent document or the non-patent literature, means any of the article which is already published or the patented. And now what is the goal for the patent search? To find the document bears the information closely similar to your invention. It may include the previous patents, journals, publication like book, public discussions like in seminars or the conferences, any brochures are there. So if anywhere in this prior art, if your things will be disclosed, then you are not eligible for the patent application. Then what are the different tools to search for the patent search? So many free as well as the paid databases are there which are used for the patent search. In that, some of the free databases are Indian Patent Office, INPAS, Indian Patent Advanced Search System, which gives the idea about the patent which are filed into the India. Then ASPASNet, that is a European patent database which gives the details about all the patent applications which are filed in the all over the world. Then Patent Scope, WIPO, that is also give the idea about the patents which are filed in the all over the world. Then the Google Patents, Free Patents Online, USPTO means US Patent Office. So it will give the idea about the patents which are filed in the US only. So these are the different type of the databases which you can use to perform the patent search. Now, what is the need for the patent search? To learn more about your field and technology. If you are in the last year student and you have to submit some project to your institution. So if you are working on some new technology, so that can be patented, right? So for that, how you can know that your technology or the field will be a new? So for that you can search out the patent search. Based on that you can find out some things. Let's for example, I have given that the one brick is prepared from the some a chemical waste. So that brick and the chemical waste related patent you have to search. If they have already this patent will be there, then there is no use or there is no thing to work on that particular product, right? So you have to move ahead and search for some another related areas which in which the work will be not happen more, and you can choose those field or the technology. So if you want to learn about that particular technology or the field, then also this patent search will be useful. Then to write the patent application, if your invention will be patentable, then to write the patent application, that may be useful for you. To understand the competition in the market for the industry perspective, to avoid the patent infringement, means if you are in the industry or you are thinking to start your startup, then you have develop one product but you don't know whether it will be protected by some others patent or not. So for that, if that will be protected by the some others companies or the person's name by the way of the patent, then if you are selling those product, that person will be give a legal notice to you to sorry, to stop for manufacturing your product. So for that, if you want to avoid those legal battles, first you can search whether your product or the process or the technology which you are working on, that will be protected by some other person or not before going to the market. Then to save the cost of the patenting process, to get the idea about the market informations. Then what the patent search methodology, to determine the purpose of the search database to be searched, need to be searched. So first you have to check whether, suppose आप कोई स्टार्टअप लेके आ रहे हो, वो स्टार्टअप में आप ऐसा सोच रहे हो कि मैं ये पर्टिकुलर प्रोडक्ट का सेलिंग करूंगा और मैन्युफैक्चरिंग करूंगा, बट आपको वो प्रोडक्ट कैसे बनाना है वो सब आपको पता है, बट आपको वो पता नहीं है कि उस पर किसी ने पेटेंट लिया है कि नहीं लिया है. अगर किसी ने पेटेंट लिया होगा तो वो पर्सन आपके मतलब आपके सामने लीगल सूट करेगा, लीगल नोटिस भेजेगा और सारी लीगल बैटल में चला जाएगा वो पूरा प्रोसेस. तो आप मार्केट में एक तो इनिशियल स्टेज में हो स्टार्टअप में, प्लस में आप मार्केट तो कर ही नहीं पाओगे, रेवेन्यू तो जनरेट नहीं होगा और साथ में ये लीगल बैटल भी हो जाएगी. तो उस टाइम पे आपका पर्पस ऑफ सर्च क्या रहेगा कि मुझे ये सर्च करना है, उसको फ्रीडम टू ऑपरेट सर्च बोलते हैं, मुझे ये सर्च करना है कि मार्केट में मेरी प्रोडक्ट के रिलेटेड कोई पेटेंट है कि नहीं है. तो वो पर्पस डिफरेंट हो गया और उसके बेसिस पे आप उस एंगल से और वो डायरेक्शन में यू विल डू दिस सर्च. अभी सेकेंड पर्पस ऐसा है कि आप आपका स्टार्टअप है या तो आप इंस्टीट्यूशन में है और आपका लास्ट ईयर प्रोजेक्ट में आप ऐसा न्यू इनोवेटिव आइडिया लेके आए हो कि जिसको आप सोच रहे हो कि मुझे पेटेंट इसके लिए अप्लाई करना है। तो अगर आप उसके लिए आपको पेटेंट अप्लाई करना है तो आपको पहले देखना पड़ेगा कि ये थिंग्स ऑलरेडी कहीं पे पेटेंटेड है कि नहीं है, या तो पेटेंटेड नहीं है तो किसी ने इस पे आर्टिकल्स लिखा है, रिसर्च आर्टिकल, या तो कहीं पे भी ये थिंग्स नोन है कि नहीं है। तो उसके लिए आपका अभी सर्च कैसा हो जाएगा कि आपको वो डायरेक्शन में देखना पड़ेगा कि ये थिंग्स नोन है कि नहीं है। अगर नहीं है तो यू आर एलिजिबल टू अप्लाई फॉर द पेटेंट। और सिमिलरली जब वो मार्केट रिलेटेड सर्वे करते हैं तो उस टाइम पे आपको ये चीज़ देखनी है कि इस पे पेटेंट है कि नहीं है। अगर पेटेंट है सो यू हैव टू स्टॉप वर्किंग ऑन दैट पर्टिकुलर प्रोडक्ट। सो फर्स्ट you have to decide the purpose of your search, and after that you can select the database for that, then gather the information about or the data, based on that you can search। आपका जो पर्टिकुलर प्रोडक्ट है उसके आपको सिनोनिम्स लिखने पड़ेंगे कि सपोज पेन के लिए कोई पेटेंट फाइल की गई है, सो हम लोग इसको पेन बोलते हैं, लेकिन अगर टेक्निकल टर्मिनोलॉजी में वी कैन से इट्स अ राइटिंग इंस्ट्रूमेंट, राइट? It may be a pen, it may be a pencil, sketch pen, like that. So writing instrument is a technical term. So अगर आपने पेन लिख के सर्च कर दिया तो आपको शायद कोई ऐसी रिलेवेंट पेटेंट ना मिली कि जो आपकी जो टेक्नोलॉजी है उससे रिलेवेंट है कि नहीं है। लेकिन अगर उसमें से कोई ऐसी पेटेंट्स थी कि जो आपकी टेक्नोलॉजी के रिलेवेंट थी बट उसमें उन्होंने लिखा था राइटिंग इंस्ट्रूमेंट, सो वो मिस हो गई आपसे। सो आपको ऐसे डेटा सब गैदर करना है कि आपकी जो इन्वेंशन है, आपका जो रिसर्च वर्क है, पहले उसको आप राइट डाउन करो। उसके या तो आपके पास जो भी आइडिया है उसको राइट डाउन करो, वो आइडिया का कोई भी सिमिलरिटी, कोई सिनोनिम्स है तो वो आप जनरेट करो कि इसके ये सिनोनिम्स हो सकते हैं। उसका टेक्निकल एस्पेक्ट देखो, उसका सब्जेक्ट मैटर देखो, देन प्रिपेयर अ सर्च क्वेरी बाय यूजिंग द बुलियन ऑपरेटर। सो बुलियन ऑपरेटर इज लाइक दैट, एंड और हैशटैग, नॉट लाइक दैट। सो सपोज आप राइटिंग इंस्ट्रूमेंट ले रहे हो, आप पेन के लिए ही मतलब सर्च कर रहे हो, आपको आपका इंस्ट्रूमेंट, आपका जो इन्वेंशन है वो पेन के रिलेटेड ही है, पेंसिल के रिलेटेड नहीं है। सो आप क्या लिखोगे कि राइटिंग इंस्ट्रूमेंट एंड पेन, सो मीन्स इट गिव द रिजल्ट्स ऑफ द बोथ, मीन्स जहाँ पे भी राइटिंग इंस्ट्रूमेंट होगा एंड पेन होगा वो लोग आपको रिजल्ट देंगे। देन आप अगर और यूज कर रहे हो राइटिंग इंस्ट्रूमेंट और पेन, तो वो क्या करेगा, राइटिंग इंस्ट्रूमेंट अलोन होगा उसके भी रिजल्ट देगा, जो पेन है उसके भी रिजल्ट देगा, और दोनों कंबाइन होंगे उसके भी रिजल्ट देगा। तो वो रिजल्ट ज्यादा होंगे, कुछ भी मिस होने का चांसेस कम है। देन थर्ड वन इज दैट कि आप ऐसा लिख रहे हो राइटिंग इंस्ट्रूमेंट नॉट पेंसिल, मीन्स जो पेंसिल वर्ड है वो नहीं आना चाहिए, राइटिंग इंस्ट्रूमेंट में सिर्फ जो पेन है वही आनी चाहिए, तो वो उस तरीके से आपको रिजल्ट देगा। सो टू फर्स्ट यू हैव टू find out the keywords, then you have to prepare the search query by using this type of the boolean operators, then conduct the search, evaluate the results, and if the more results are there or they are little bit relevant or irrelevant to your technology, then modify search strategy, then repeat the search, analyze, summarize, and report those your search. This is all the methodology for the patent search. Now as I told, the different boolean operators they are used, right? So in that, and, or, not, star mark, hashtag, question mark will be there. So if you are anywhere, if you are using the and word, means the pen and the writing instrument, so the things, both the things are in combination if available in the any of the document, then those result will be come out. Then if you are using the or means the one or other or the both the term will be in the document, it will give the result like that. Then not one term in the present and other term is not present, so that will be result will be based on that. Then if you are adding the star mark over there, asterisk mark will be there. So if let's for example we are taking the example of the compo, so if you are putting the asterisk marks on the compo, so it will cover the results of the composition after anything after the compo, either it's the composition, it's compound or composite or like that. So everything will be covered by the way of this type of the search. Then the question marks, so it is for the 0 and 1 character. So for less for example, if you are writing the pen then putting the question mark, so it will give the results of the pen as well as the in the plural sense is the pens also. Then in the hashtag, it's exactly one character. If you are putting hashtag as a prefix in front of the pen, then it will only give the results of the pens only. So by this way you can conduct the search by using this type of the boolean operator, and based on that you will generate your search query. Then for the patent search also this e-gateway will be used, and In that, this, if you are clicking on the e-gateway and in the patent search, then you will public search, you will get this type of the window over there. In that also there are multiple fields are there. In the title you can search. If you want to search in the abstract, then in the whole the patent document, that is the complete specification, then based on the application number, applicant name, inventor name, applicant which office you have applied for the patent office, then which type of the classification, particular classification will be there. So based on the different type of the search strategy will be there, and you can search over there. But generally if you are in the very ideation stage, आपके पास just idea है, आपको पता नहीं है कि इस पे किसने पेटेंट लिया है नहीं लिया है कुछ भी, so you can use this keyword search कि आप टाइटल, एब्स्ट्रैक्ट और कंप्लीट स्पेसिफिकेशन में कहीं पे भी आपका जो भी कीवर्ड है लाइक पैन and the writing instrument, so you can add over there. You can select the boolean operators from over here, and or and not. So based on that आप search कर सकते हो ये database पे for the patent search. This is the Indian patent database. Now second one is the यूरोपियन पेटेंट डेटाबेस, दैट इज द एस्पासनेट. इंडियन पेटेंट डेटाबेस में ऐसा होगा कि जो भी पेटेंट्स इंडिया में फाइल हुई होगी उसकी ही डिटेल्स आपको मिलेगी. And in this Espasnet and the WIPO, you will get all the patent details which are filed in all over the world. So in that also the similar things you have to done. If you have any number will be there, or if you have any keyword, you can directly add over here, or you can perform this advanced search by using these boolean operators in the title field or the title abstract field. Then in this is the WIPO. In the WIPO, or this is the World Intellectual Property Organization. In that, if you are selecting the search in the WIPO, so it will give the different type of the search. In that you will select the field combination search for the keyword search, and if you are clicking the field combination, then this type of the window will be open. And in that also, in the title and abstract, by using these operators you can perform the keyword search. You can add your search query over here and you can perform the search. Then this is a Google patent search. In that also by the keyword search you can add the query over here. You can limit it by the way of the date, you can limit it by the way of the inventor name, assignee name, or the applicant name. So this is all about the patent search and the IPR search, and the basics about the IPR and the different types of the intellectual property rights, and the more about the patents. Hope this will be clear to you all.
Okay. Ma'am, should we go for the question session?
Yes, sir.
Okay, participants, if you can hear me, you can ask your question in the chat box so that we can put it, or you can make your mic on and ask the question. If anybody, unmute your mic and ask.
And in future perspective also, if you are come up with any of the idea, and in that if you are performing the patent search or like that activity, and if you are facing any of the issue in that, then also you can contact me by way of the mail ID and the number which I have given into this screen.
Ma'am, if the students are preparing their questions, may I ask a question?
Yeah, sure.
But what is the advantage of that means we are patenting in some foreign country instead of in India?
So that is basically a person interest, based on the person interest. If some companies or the person who is more interested to market their product into the some particular country, let's for example in that person having an industry into the US, and they are marketing and manufacturing or selling their product in the US territory only. So that in that case they are preferring to file the application into the US territory rather than in the India, because the patent is the territorial right. If you are applying in India, then it's limited to the India only. If you are applying in the US, then it's limited to the US only.
Limited to India means we can sell the product anywhere in the world. Is it right?
You can sell over there, but if some other person who is from the US, let's for example, okay, you are Indian citizen, you have applied patent in the India, and that will be granted. Now you are manufacturing in the India and you are selling in India as well as in the US. But if any person who is from the US that come to know that okay, this type of technology is there, and they are copying your product and they are also selling that product into the US, but as you are protected your invention in the India only, so you cannot stop that person to selling or
Okay.
manufacturing product in the US. But that person, if they are manufacturing and selling in India, then you can stop that person because you have a rights of the patent in Indian territory only.
Okay. One more question from the participants' point of view.
Yes.
Can I make a copy of a product and not filing for the patent, and I can market the things? I will not get any legal notice.
That you have to check whether that particular which the product on which you are copying, whether it will be protected by any of the IP right or not in India particularly. So if it is protected by the some of the IP right, either it's a patent or trademark or any of the right, then you will definitely you will get the notice of that, because that if the person is that much strong and having watching on that which are the competitors come into the market who are copying my product, then they will apply or they can file the suit against you.
Okay. What is the cost for patent filing for a common man, or common
For the
person?
now the as per this last year amendment, the any of the individual, startup, small entity, and any of the institutional educational institute, they're all having in same category. For the similar fees will be applied. So from the whole the patent application, from the filing to grant, it will be cost approx 8,000 for the normal way, and if you can expedite that process, then it will be a 12,000. That is the patent office fees, and the professional fees will be vary based on the person from where you are taking the work. That patent agents or the law firm having a different fees as a professional fees, but the office patent office fees will be this.
Okay. Is there any institution? I think GTU is also helping in doing the patent filing. Is
Yes.
there any other institution who can help you in terms of money
I
to?
think iHub will be also helpful, helping. Then GUSSEC is also helping. But
Okay.
generally, rather than these universities or the helping things, but the particular institution having a SSIP cell. So if
Okay.
any institution having SSIP cell, then they are providing the limited fund to the, not limited, but now they are providing the enough fund to the institution for particular patent. So generally most of the engineering colleges, they are preferring to take a fund from the SSIP only.
Okay, ma'am. One more question just came to my mind.
Hmm.
You have shown some chair, different arrangement of chair.
Yes.
So can a simple carpenter can patent his or her product or design? Because
Uh,
I don't think that a carpenter can go for the patent filing.
Yes, but if that person having that much of the awareness or the knowledge about this field, so they can, because there is no limit that person who can apply for the patent. Any of the researcher, any of the Indian citizen that can apply for the any of the IP, either it's a patent, design, trademark, any of things. But due to lack of awareness, that person having don't having a knowledge about that, so that person cannot go for that. And one more thing is that if that carpenter is not that much of industrial mindset like that, so if any of the instrument will be there, like in the chemical engineering or in the pharmaceutical field or biotechnological field, any of the machine will be there which are a little bit unique to manufacturing the vaccines, let's for example. So that instrument having that much of the value, if any other person or any other industry copying those things, so it will be affect that particular the main industry. So those type of the industries are looking forward this IP things to stop others and to survive in the market or to create the monopoly in the market. But in the academia perspective, many of the students which are not come up with any of the very unique instrument, but they have changed some of the instrument for their practical purpose or some like that, so they can preferring this design registration
Okay, ma'am.
because it's cost very less, and if for that only the new thing will be required, the look wise it will be required. There is no technical data or the experimental data that you have to give to the patent office design registry, so people are preferring those things also.
Okay, ma'am. Thank you for the questioning session. And one more thing, participants, just now we are putting the link for giving your feedback. We'll allow 10 minutes. So be prepared with your answer see go through the chat box, and for the first session your feedback is important. Based on that, your attendance will be taken care. And one more thing, ma'am, as I said, and as you said, as some common people like some artisans who are not knowing about these patents, so our students can help them out, even if they are not, they themselves are not the innovators, पर वो उनको help कर सकते हैं अपने आजू बाजू में कहीं पे ऐसा कुछ हो रहा है, so their earning can be increased.
यस यस श्योर सर, वो मतलब जरूरी भी है कि टू क्रिएट द आईपी अवेयरनेस, बिकॉज 7 years बैक व्हेन आई हैव स्टार्टेड माय करियर, सो उस टाइम पे जो सिनेरियो था उसमें अभी बहुत चेंज हो रहा है, बिकॉज गवर्नमेंट ऑल्सो इन्वॉल्विंग इन द स्टार्टअप एंड द आईपी अवेयरनेस रिलेटेड. और मेरे पास भी अभी इतने 2-3 क्लाइंट्स ऐसे हैं कि दे आर ओनली द 12th पास, बट वो कहीं पे भी उनको अवेयरनेस रहता है कि कैसे पेटेंट करना है, और उन लोगों का जो इन्वेंशन होता है ना वो एक्चुअली दे आर यूजफुल फॉर द सोसाइटी, बिकॉज वो लोग उस तरीके से वो पूरा देखते हैं कि चलो ये प्रॉब्लम सोसाइटी को फेस हो रहा है, पीपल को फेस हो रहा है, तो हम लोग उस एंगल से उनमें कुछ टेक्नोलॉजी डेवलप करें, और इफ दे हैविंग अ लिटिल बिट नॉलेज अबाउट द पेटेंट एंड ऑल लाइक दैट, सो दे कैन स्पेंड एंड आफ्टर दैट दे कैन अर्न.
Okay, ma'am. Thank you very much. We please be online for another 4-5 minutes.
Yeah,
And
sure, sir.
I'm also thankful to you on behalf of our college, our trust, our principal sir, our administration sir, and from our um, uh, IIC members, as well as the management governing body members. So we'll hope that in future also we will arrange such type of sessions in which you will join with us.
Sure, sir. Sure, sir.
And
Because this is just the beginning about the basics about IP. Then the patent search in detail. Then patent drafting, how you can write the patent application, how you can file. So there are whole series will be there. You can invite me anytime to conduct any of these sessions, because it's a whole the series like program will like that, the patent related things.
okay. Thank you, ma'am, for helping us out. And at the end, I would like to thank the Institute Innovation Cell, as well as the Ministry of Education Innovation Cell that is run by Government of India, and AICT for choosing us or selecting us, our institute, and sponsored us for conducting the program. And one more thing, participants, don't forget that our afternoon session is also there. That is, that will be on entrepreneurship, or what are the opportunities for new entrepreneurs. Will be and you can join at around 1:30. Should you stop here, sir? I don't think any more question will be there. We'll be stopping here. Thank you, ma'am.
Yeah, thank you so much,
Thank you
sir.
again. Thank you again.
Yeah, thank you so much, sir.